Tonight, the Supreme Court has redrawn the boundaries of our digital lives. In a decision that will echo for generations, the highest court in the land has stepped into the heart of the digital age, reshaping the rules that govern how we live, communicate, and protect our most personal information. The weight of this moment is felt not just in the marble halls of justice, but in every home, office, and device across the country. This landmark ruling will fundamentally change how Americans relate to their government and their own private information. For millions, the question of digital privacy has always been abstract, something debated by experts and politicians. But tonight, it becomes real. The decision will affect how we trust our institutions, how we communicate with loved ones, and how we safeguard our identities in a world where so much of who we are exists online. The case Digital Liberty versus United States sets a precedent for digital rights worldwide. Legal scholars are already calling it a turning point, not just for America but for democracies everywhere. The world is watching as the United States redefines the balance between national security and personal privacy in the digital era. It's not just about legal arguments, it's about your emails, texts, search history, and everywhere your phone goes. Every ping, every swipe, every message you send or receive could now be subject to new rules. The decision reaches into the most intimate corners of our lives, raising questions about what privacy means in a world where our devices are always with us. For years, the debate has raged. How much of our digital footprint can the government access without our knowledge? Lawmakers, activists, and tech companies have clashed over where to draw the line. Tonight, the Supreme Court has drawn that line, but not without controversy. The ruling is already fueling passionate debate on both sides of the aisle and in the streets. This decision provides a decisive answer, sparking both celebration and concern. Some hail it as a victory for personal freedom, while others fear it could open the door to new forms of surveillance. The nation is divided, with emotions running high as people try to understand what this means for their daily lives. The implications stretch from Congress to Silicon Valley and right into your living room. Lawmakers will need to respond, tech companies must adapt, and families everywhere are left to wonder how their digital habits might change. The ripple effects will be felt in boardrooms, classrooms, and at kitchen tables across America. Tonight, we break down what led to this moment, what the justices decided, and what it means for your future. We'll explore the history, the arguments, and the far-reaching consequences of a ruling that will shape the digital landscape for years to come. Stay with us as we unpack the story behind this historic night. The story of digital liberty versus United States didn't start in the marble halls of the Supreme Court, but in the heart of Austin, Texas. Here Maria Flores, a hard-working small business owner, opened her shop each morning, never imagining she would become the face of a national debate over privacy in the digital age. Maria's life was much like that of millions of Americans, busy, connected, and increasingly reliant on technology to run her business and stay in touch with loved ones. One day, during a sweeping federal investigation, government agents quietly accessed years of Maria's digital life. They combed through her emails, business documents, and even tracked her location history, all without obtaining a traditional search warrant. For Maria, this intrusion was invisible at first, but its impact was profound. The digital footprints she left behind, which she thought were private, became evidence in a case she didn't even know existed. Eventually, Maria was cleared of any wrongdoing, but the experience left her shaken. With the support of the Digital Liberty Foundation, a non-profit dedicated to defending privacy rights, she decided to take a stand. Together they sued the federal government, arguing that her Fourth Amendment rights, protecting against unreasonable searches and seizures, had been violated in the digital realm. The government, however, defended its actions by pointing to laws and legal precedents written decades ago, long before the internet, smartphones, or cloud storage existed. These outdated rules, they argued, still applied, even as technology had transformed the way people live, work, and communicate. In the first round, a district court sided with the government. The judge cited old cases about privacy and the so-called third-party doctrine, which held that information shared with companies, like phone records or bank statements, wasn't protected by the Constitution in the same way as private papers in a desk drawer. But on appeal, the tide began to turn. The appellate court recognized that the sheer volume and sensitivity of modern digital data, tracking where we go, who we talk to, and what we think, demanded new legal protections. They ruled in Maria's favor, acknowledging that digital privacy is fundamentally different from the past. The case quickly gained national attention. The Supreme Court agreed to hear it, setting the stage for a historic showdown that would determine the future of privacy in America's digital era. The government argued that these investigative tools were essential for protecting national security and fighting crime. They warned that requiring warrants for digital data could hamper law enforcement and put the country at risk. On the other side, civil liberties advocates, privacy experts, and ordinary citizens warned of the dangers of unchecked surveillance. They argued that without strong protections, anyone's digital life could be exposed to government scrutiny, eroding the freedoms at the core of American democracy. The stakes were enormous. Could the government access your emails, texts, and location data without a warrant? Or would the Constitution's promise of privacy extend into the digital world we all now inhabit? As the justices deliberated, the nation waited. For Maria Flores, and for millions of Americans, the outcome would shape the boundaries of privacy and government power for generations to come. At the heart of this case is the third-party doctrine, a legal principle that has shaped the boundaries of privacy for decades. This doctrine, though not widely known outside legal circles, has had a profound impact on how our personal information is treated under the law. The third-party doctrine is a rule from the 1970s, a time when technology was far less advanced and the digital world as we know it today was unimaginable. Back then, the law was grappling with new questions about privacy, but the scope was limited to things like landline phone calls and paper bank records. According to this doctrine, you lose your expectation of privacy when you voluntarily share information with companies or third parties, such as your phone records, the numbers you dial, or your monthly bank statements. The government could access these records without a warrant, simply because you had shared them with a business. But today, our lives are intertwined with technology in ways the 1970s could never have predicted. We share far more than just phone numbers or account balances. Our smartphones constantly transmit our locations, our internet searches reveal our interests and concerns, and our private messages document our most personal conversations. Every swipe, click, and tap leaves a digital footprint. Critics argue that applying this old doctrine to the vast amounts of modern digital data gives the government unprecedented power to monitor citizens. They warn that the doctrine, if left unchanged, could allow authorities to access detailed records of our movements, communications, and even our thoughts, all without meaningful oversight. In the courtroom, the justices wrestled with tough questions. Is using a smartphone truly voluntary in today's world when so much of daily life depends on digital connectivity? Where should the line be drawn between legitimate law enforcement needs and the right to privacy in a connected society? Could the government track someone's movements for months or even years just by collecting data from their devices? How much surveillance is too much, and when does it cross the line into an invasion of privacy? The outcome of this case would set the rules for privacy in the digital age, determining how far the government can go in accessing our digital lives, and what protections citizens can expect as technology continues to evolve. Would the Fourth Amendment, which guards against unreasonable searches and seizures, adapt to the realities of the digital era, or would it risk becoming obsolete in the face of rapid technological change? Ultimately, the court was asked to strike a delicate balance, protecting the needs of law enforcement to keep society safe, while also safeguarding every citizen's fundamental right to privacy in a world where our personal data is more exposed than ever before. On December 8, 2025, the Supreme Court ruled 6-3 for the Digital Liberty Foundation. The majority declared Americans have a reasonable expectation of privacy in their digital records. Law enforcement now generally needs a warrant to access emails, location history, and search data. The court likened digital data to the area around your home, protected by the Fourth Amendment. The decision overturns decades of precedent, rejecting the idea that using technology means giving up privacy. Dissenting justices warned this could hinder investigations, but the majority insisted the warrant requirement is a cornerstone of justice. The ruling doesn't block government access, it just raises the bar. The Constitution, the court said, must evolve with technology. The reaction was swift and passionate. Civil liberties groups called it a historic victory for freedom. The Digital Liberty Foundation celebrated the affirmation of online privacy rights. Law enforcement and some lawmakers warned the ruling could hamper investigations and benefit criminals. The Attorney General promised a careful review, noting the impact on national security. The White House pledged to implement the ruling while balancing privacy and safety. Tech companies welcome the clarity, saying it helps them protect users and demand warrants. For years they'd been caught between government requests and user trust. Now, they have a clearer legal standard. The decision has ignited a fierce political battle in Washington. Some lawmakers are pushing for new laws to strengthen digital privacy, introducing the Digital Privacy Act of 2026. Others argue the court went too far, warning of new blind spots for national security. The fight over exceptions for national security is just beginning. The ruling is set to be a major issue in the 2026 midterm elections. Candidates will be pressed on where they stand, privacy or law and order. The executive branch must now overhaul investigative procedures across agencies. This is more than new rules, it's a cultural shift for government. Balancing privacy and security will test every branch of government. The economic impact is already rippling through major industries. For tech companies, the ruling brings legal clarity and a chance to rebuild trust. They can now market privacy as a feature, especially to global customers. But compliance costs will rise, especially for startups. The data broker industry faces new uncertainty as the ruling raises questions about commercial data collection. Other sectors, like insurance and finance, are watching closely. Internationally, the decision could ease tensions with Europe over data privacy, making cross-Atlantic business easier. Thousands of companies stand to benefit from a more stable data-sharing environment. Billions in digital trade could be unlocked. For you, the biggest change is stronger privacy for your digital life. Now the government needs a warrant to access your emails, messages, and location history. This empowers you as a digital citizen. Using technology doesn't mean surrendering your rights. Activists, journalists, and minorities gain new protection from surveillance. But private companies can still collect your data. This ruling only limits government access. The fight for consumer privacy laws continues, but this decision gives that movement momentum. Your relationship with technology and government has changed. The Constitution's protections now follow you online. Tonight marks a turning point in American history. The Supreme Court's decision redefines privacy for the digital age. It updates the Fourth Amendment for an era of big data and constant connectivity. The debate over privacy and security will continue, but digital rights now have their strongest defense yet. This story began with one person and ended with a ruling that affects us all. Our founding principles are alive, adapting to new challenges. The future of privacy is in our hands. As citizens, consumers, and voters, the digital age has a new rule. Your rights travel with you, wherever you go.